Welcome to our deep dive into evidence law, specifically focusing on the Hearsay rule. This rule is a cornerstone of trial practice and is tested extensively on the bar examination, so mastering its precise definition is essential. We begin by looking directly at Federal Rule of Evidence 801(c), which provides the controlling definition. Hearsay is defined as an out-of-court statement offered in evidence to prove the truth of the matter asserted in the statement. Let us break down those three critical components. First, it must be a statement, which includes an oral or written assertion, or even non-verbal conduct intended as an assertion. Second, it must have been made out of court. Third, and most crucially, it must be offered for the truth of the matter asserted. If the statement is offered for any other purpose, such as to show the effect it had on the listener, or because the statement itself has legal significance, it is not hearsay. Understanding this core definition is the gateway to analyzing all subsequent exceptions and exclusions. Now that we have the precise definition of hearsay, we must understand the fundamental policy reason why the law generally excludes such statements from evidence. The exclusion is rooted in ensuring reliability. When a witness testifies live in court, we have several safeguards built into the trial process. Hearsay statements bypass these safeguards, leading to four primary trustworthiness concerns. First, there is the concern regarding perception. Did the declarant actually see or hear what they are reporting? Second, we worry about sincerity. The declarant was not under oath, meaning there is no penalty for lying. Third, we face issues with narration. The statement might be unclear, ambiguous, or poorly phrased, lacking the precision of live testimony. Finally, and perhaps most importantly, we lose the ability to cross-examine the declarant. We cannot test their memory, perception, or sincerity directly before the jury. These four weaknesses, perception, sincerity, narration, and cross-examination, are the bedrock justification for the Hearsay rule. We just established the four core reasons why the law generally excludes hearsay statements. However, the Hearsay rule only applies if the statement is offered to prove the truth of the matter asserted. If the statement is offered for any other purpose, it is technically not hearsay and is admissible. There are three main categories where an out-of-court statement is admitted for a non-truth purpose. First, to show the effect on the listener. For example, if someone shouts "Look out, a car is coming," that statement is admitted not because a car is actually coming, but to show the listener was warned or put on notice. Second, legally operative facts. These are statements that have legal significance simply by being spoken, such as the words forming a contract or a libelous statement itself. Finally, we must address statements that are defined as not hearsay under Rule 801(d), even though they are out-of-court statements. The most common example here is a prior inconsistent statement used solely for impeachment purposes. Unless the statement meets the specific requirements of Rule 801(d)(1)(a), it is only admitted to show the witness is unreliable now, not that the prior statement was true then. This distinction between true hearsay and statements admissible for other purposes is critical for the bar exam. Now that we understand which statements are admissible because they are not offered for the truth of the matter asserted, we return to true hearsay, statements offered for the truth that require an exception. The federal rules divide these exceptions into two groups, those in Rule 803, which apply regardless of availability, and those in Rule 804, which apply only if the declarant is unavailable. This chapter focuses on Rule 804. Before applying any Rule 804 exception, we must first establish that the declarant is legally unavailable under Rule 804(a). This is a mandatory threshold requirement. Rule 804(a) lists 5 specific grounds that qualify a declarant as unavailable. These are: 1. The declarant is protected by privilege. 2. The declarant refuses to testify despite a court order. 3. The declarant claims a lack of memory about the subject matter. 4. The declarant is dead or suffers from an illness making testimony impossible. Or 5. The proponent could not procure the declarant's attendance by process, meaning their absence was procured by the offering party. We must confirm one of these 5 conditions before moving on to the exceptions themselves. Having confirmed the declarant is unavailable under Rule 804a, we now examine the first major exception, former testimony, codified in Rule 804b(1). This exception allows prior testimony given under oath to be admitted in the current proceeding, provided certain strict conditions are met. First, the statement must have been given as testimony at a trial, hearing, or lawful deposition, and crucially, it must have been given under oath. Second, and most importantly for bar exam purposes, the party against whom the testimony is now offered must have had both an opportunity and a similar motive to develop that testimony previously. This means the current opponent must have been the same party, or someone with identical interests, in the prior proceeding, and they must have had the chance to question the witness fully through direct, cross, or redirect examination. This dual requirement ensures the reliability derived from prior adversarial testing is preserved. Building upon the requirement that the declarant must be unavailable, we now examine the second major exception under Rule 804b, the statement against interest, codified in Rule 804b(3). This exception is powerful because it does not require the declarant to have been subject to prior cross-examination. For this statement to be admissible, the statement must have been so contrary to the declarant's interest when made that a reasonable person in their position would not have made the statement, unless they believed it to be true. We specifically look for 3 types of interest that are jeopardized: pecuniary interest, proprietary interest, or penal interest, meaning the statement exposes them to criminal liability. Critically, unlike former testimony, the declarant need not be a party to the current lawsuit for this exception to apply. The focus is solely on the inherent trustworthiness derived from the statement's self-damaging nature, which we visualize here as the statement heavily outweighing any potential benefit to the declarant. Moving past statements against interest, we arrive at the fourth and perhaps most dramatic exception under Rule 804, dying declarations, found in Rule 804b(2). This exception is extremely narrow in scope. First, the statement is admissible only in 2 specific types of cases: homicide prosecutions or civil actions. Second, the statement must concern the cause or the circumstances surrounding what the declarant genuinely believed to be their impending death. The critical element here is the declarant's subjective state of mind. They must truly believe death is imminent. A mere possibility of death is insufficient. This belief in immediacy is what substitutes for the oath, providing the necessary assurance of truthfulness. We rely on the solemnity of the moment to ensure reliability, which we illustrate now. We have now covered the 3 most frequently tested exceptions requiring unavailability. Our final stop under Rule 804 is the exception for statements of personal or family history, codified in Rule 804b(4). While less common on the bar exam than the previous 3 rules, you must still recognize its existence. This exception allows hearsay regarding the declarant's own history, such as their birth, death, marriage, or other significant life events. Crucially, it also covers statements about the history of another person closely related to the declarant, like a parent, sibling, or child. The rationale here is that statements about one's own lineage or major life events are often made when the declarant has no motive to lie, similar to the solemnity we discussed previously, though without the immediacy of death. Think of family Bibles or oral traditions passed down through generations. We illustrate this concept of lineage now. That concludes our deep dive into the 4 exceptions under Rule 804 where the declarant must be unavailable. Before we wrap up, let's synthesize the entire Rule 804 analysis for your bar exam strategy. Remember the flow. First, confirm the statement is hearsay. Second, establish unavailability under Rule 804. A. This is the mandatory gateway. If the declarant is available, these exceptions are irrelevant. Third, check the 4 specific exceptions: former testimony, statement against interest, dying declaration, and family history. To keep this straight, remember the acronym TIDE for the exceptions: testimony, former, interest, against, death, dying declaration, and events, history. Always check unavailability first. Mastering this structure ensures you tackle any Rule 804 scenario efficiently. You have now covered the core hearsay rules tested on the bar exam. Keep reviewing these structures, and you will succeed.